Hi, my name is Yash. Today's my topic is e-discovery, legal challenges in digital age. So first we will talk about what is e-discovery. Uh, E-discovery, also known as electronic discovery, refers to discovery in legal proceedings such as litigation, government investigations, or Freedom of Information Act request, where the information sought is in electronic format. So basically, it says that electronic discovery is the process when people gather and share evidence using computers and other electronic devices for a legal case. It happens at the start of lawsuit when everyone involved has to give important documents and evidence that relate to the case. E-discovery means any activity in which electronic data is involved. It refers to any process in which electronic data is needed, placed, and examined, which could be beneficial and can be considered as evidence in criminal civil cases. So, e-discovery has advantages and disadvantages both. So, first we will talk about advantages. First one, authentication of communication. Electronic communication is prohibitively difficult to fake. Metadata embedded in the communication will reveal facts like the date and time that the communication was sent or posted, which created irrefutable evidence in a legal proceeding. So it says that it's really hard to fake electronic messages. Information hidden in the messages, like when they were sent or posted, can't be changed easily. This kind of information makes a solid proof in a legal case. Second, faster processing. When communications can be conveyed electronically and the parties involved don't need to waste time correcting, printing, and sending hard copies of communications back and forth the time, so the case can proceed at a good pace. Proceedings won't get bogged down in delays that are entirely avoidable when e-discovery is used. So it says that when people can send messages electronically instead of using paper, it saves a lot of time. This means that the legal case can move forward easily and quickly because there is no need to wait for printed documents to be sent back and forth. Using e-discovery prevents unnecessary delays in the legal process. Third, no data is ever really lost. There's saying that once you put something online, it's there forever, and to an extent, that's true. Even when communications are deleted or destroyed, there are traces of those communications left behind. Those traces can be pieced together to provide a new copy of communications or to rebuild enough of the original data that it can be used as evidence in a legal case. So when we post stuff online, it usually stays there. Even if you delete it later, even after deleting, bits of it can still be found. These bits can be used to recreate what was deleted or find enough evidence for a legal case. All modifications or deletions are documented. When electronic documents and communications are edited or modified, all of those changes are documented so that there is no one for one party to change something without the other party knowing. That way, all communications are fair and visible to all of the parties involved. So, when we change digital documents or messages, those changes are kept tracked. This makes sure nobody can change it easily. It's fair and everyone can see what's going on. Wide variety of opportunities for evidence. Digital evidence like websites, social media posts, photos, etc. can give a lot of important information. In fact, really strong evidence is often found in these digital files. So here we will talk about some disadvantages of e-discovery. First one is the costs. E-discovery indeed takes less time than physically gathering communications, but it still does take time, and the use of e-discovery can be expensive because most companies fail to implement retention policies that reduce the amount of data. E-discovery collection, review, and production is expensive. Second, cybersecurity. One of the biggest disadvantages of using e-discovery is the security of electronic communications. While most of the time electronic communications are very safe, there is always the chance that communications could be compromised by an outside actor or held for ransom in a cyber attack. Third, preserving data can be a challenge. Another problem that arises with e-discovery is preserving data that has been collected in a way that will keep it safe. So, this disadvantages is e-discovery saves time compared to gathering physical documents, but it's still time consuming and costly because many companies lack data retention policies. Cybersecurity risks include potential compromise of electronic communications. Preserving collecting data securely possesses challenges. So here we will talk about challenges to e-discovery in India. Firstly, there are no provisions laid down in any of the acts related to internet policies and its privacy. There is a lack of knowledge of technology, and literacy rate is also average on the scale. We have no special provisions and acts which deal with the protection of e-discovery, privacy rights and laws in India, and there is no laws related to e-discovery till now. Indian national privacy policy is still not there, and it is crucial need of it. Recently, an interim order is passed by the Apex Court, and according to it, only Indian laws and Indian firms can provide e-discovery services in India. This is again a major drawback in implementing the e-discovery records. It is going to be hard for the Indians to face the challenges, and e-discovery is still taking its shape to form an ideal shape. There are still law firms in India which are not aware of the laws in India. The first challenge appearing on the surface is the clash between the discovery of demands and protection of electronically stored data. The next challenge in e-discovery that whether the information is collected for valid purpose or not. The geographical area plays an important role in establishing an e-discovery system. So the challenges are see, in India there are no specific laws regarding internet policies and privacy, and there is a lack of technological knowledge and literacy. There are also no provisions for e-discovery protection or privacy rights. A temporary court rule says only Indian laws and companies can offer e-discovery services, which creates difficulties. Mainly, law firms in India are unaware of relevant laws. Challenges include balancing discovery demands with data protection and ensuring information collection is for valid purposes. Additionally, geographical consideration are crucial for establishing an effective e-discovery system. Thank you.